have established that states are the principal subjects of international law. This means states have the highest legal status or have the primary international legal personality in international law. Thus, states are endowed with the highest rights and duties and obligations, as international law at the end of the day is what states make of it through their consent and will. However, states are not the only actors in international law. States share the system of international law with international organizations, international courts and tribunals, international non-governmental organizations or NGOs, multinational corporations or MNCs, and individuals. These actors may be termed as subjects or objects. International organizations and international courts and tribunals are explicitly subjects of international law, meaning these are entities with rights and obligations under international law. All other entities like NGOs and MNCs are labeled as objects of international law or entities indirectly having rights under international law through the subjects of international law. However, the development and expanding political and economic capital of NGOs and MNCs complicate this categorization. NGOs are known to pressure states, while MNCs have sometimes larger capital than some states. To further complicate things, an individual is seen as a subject and an object of international law. Individuals have rights and obligations under international criminal law and international humanitarian law. To keep things simple and easy to understand, we will move away from the delineating between the subject and object definitions and just focus instead on how these multiple actors interact within the system of international law. Let's begin with the primary actor, states. An entity is a state if it meets certain elements and characteristics under international law. A treaty between American states, the Montevideo Convention of 1933 on the Rights and Duties of States, is cited as having codified customary international law on statehood. It declares that a state should possess, number 1, a permanent population, number 2, a defined territory, number 3, a government, and number 4, the capacity to enter into relations with other states. In short, for an entity to become a state, it should have people, territory, government, and sovereignty. First element is permanent population or people, which means a permanent community of persons sufficient in number and held together by a common bond of law. Race, culture, economy, and other socioeconomic classifications do not matter. There is no minimum population required so long as the international community see the people residing in the entity as permanent residents that are sufficient in number. The second element is territory, over which an entity exercises permanent sovereignty. To quote from the ICJ's Island of Palmas case, sovereignty in the relations between states signifies independence. Independence in regard to a portion of the globe is the right to exercise therein, to the exclusion of any other state, the functions of a state. This means that a state rules over a portion of land independent from other states. A territory must be definite but not necessarily settled. Thus, an entity can still claim to be a state holding a piece of territory amidst territorial conflict and boundary disputes. Furthermore, when an entity, once recognized as a state, loses its territory through foreign occupation, it does not cease to be a state. The third element is government. It is defined as an institution or a collective of institutions by which an independent society makes and carries laws and rules, usually through those who possess power and authority necessary to enable and sustain societal human relations and the exchanging of valuable resources. A callback to our lesson on the relationship between law and politics. The form and type of a government does not affect its international legal personality in international law, meaning a government may be democratic, authoritarian, or anything in between. It is the national government that has legal personality in international law. The national government is responsible for the actions of its agencies, organs, departments, and other instrumentalities of that state. So let's say if the Department of Foreign Affairs or the DFA initiates an official activity abroad, then it automatically entails the responsibility of the national government of the Philippines if that activity is brought to court in some way or form. And just like territory, the temporary loss or absence of a government, like during foreign occupation, does not terminate the existence of a state. The fourth element is sovereignty. Sovereignty simply means independence from outside control, and thus the entity has the capacity to enter into relations with other states. And to enter into international relations with other states, it is imperative to be recognized first as a state by other states. Recognition is the act of acknowledging the capacity of an entity to exercise rights belonging to statehood, meaning a state sees the other entity as an entity that can and or has performed acts of a state, like entering into foreign relations and defending its territory from rebels and revolutionaries. Furthermore, there are two views or theories about recognition. One view is the declaratory theory, which sees recognition as merely declaratory of an already existing state, meaning that entity has already possessed the other elements required by statehood, and recognition only declares it as such. Thus, a recognizing state, through the view of the declaratory theory, merely accepts an already existing situation. The other view is the constitutive theory, whereby recognition constitutes a state and therefore it is what makes a state a state. This view gives some leeway to entities lacking the aforementioned elements of statehood. Thus, political maneuvering and sufficient international clamor may either lead to the blocking or acceptance of an entity's statehood. It is important to note that these two views on the recognition of states are theories or guiding principles, and that at the end of the day, it depends on states whether or not to accept an entity as part of the international community. Note also that once an entity is recognized as a state, it cannot be unrecognized. However, if a state or a collective of states are unhappy with another state, they can simply sever diplomatic relations as a collective sanction. States can be recognized either through express recognition or implied recognition. Express recognition is through a formal statement recognizing the new state, while implied recognition is through state actions like the making and signing of a bilateral treaty. And as you may recall, only states and international organizations can directly engage with treaty making. The recognition of governments is another thing, but still similar to the recognition of a state. Recognition is automatic if ever a recognized state constitutionally transitions into another government or regime, like through an election. However, if there is an extra constitutional government change, it depends on states whether or not to recognize the newly installed government. This is highly political and depends on a case-to-case basis, and even some states today prefer not to be explicit about it. This does not totally affect the statehood of an entity in any way, but it might affect how accepted that entity is in the international community. One thing is clear though, and that is that recognition of a government is terminated if another government of that state is recognized. This is what happened when in 1979, the United States kinda recognized the People's Republic of China as the ruling government of the state of China, and thus terminated its recognition of the government of the Republic of China, the one quote-unquote ruling Taiwan, as the ruler of China.